Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with earnest money, specifically the incorrect usage of the term non-refundable earnest money. So let's get into it, shall we? First of all, earnest money, by definition, by its label, is refundable. It is held by an escrow agent until it's held by an escrow agent in trust, and you'll also hear it referred to as escrow funds or trust money. It is held by that holder in trust until that holder is directed by the parties having an interest in those funds, directed by those parties in writing on a separate document telling that holder what to do, or until the contract closes, so forth and so on. It is refundable depending upon the action, so to speak, of the party that placed it into the trust of the holder anyway, and in the first place. And that holder has a fiduciary responsibility with respect to those funds. So I understand that there are times when parties want that earnest money non-refundable, but it is refundable by nature of it being earnest money. So let's talk a little bit about contractually how you would achieve this end and this goal. So first of all, so why are we even talking about this, or in what contractual circumstance do we see this? Well, a lot of times we see this when a seller wants compensation for granting or extending a contractual contingency. And a lot of times what we'll see is on an amendment, the use or the misuse, I should say, that says earnest money shall be non-refundable, or something like financing contingency to be extended for 5 days and earnest money to be non-refundable. Something along those lines. So either we will see it mentioned in an amendment or in the purchase and sale agreement itself for granting a contingency. And either this is the pile of money that is already on hold that the buyer has already remitted to the holder, or an additional sum of money. Now, in the purchase and sale agreement in the Georgia Association of Realtors contracts, you will see, actually in the RE forms too, you will see, well, let me stick with GAR. You will see verbiage in there about option money or additional money for the seller granting the buyer's right to terminate under due diligence. But stay tuned till the end of this video. I'm going to share with you a special step, a special step authored for us by attorney Amy Davis regarding option money for the due diligence period that has something to do with the seller that you may not have considered. So thank you, Amy Davis, and stay tuned till the end of this video, and we'll talk about that. Let's look at the contracts themselves and see what they say. Well, they talk about earnest money, and in both the GAR contract package as well as the RE forms contract package, which is the contract and the standard terms, it does talk about earnest money and how the various ways it can be dispersed by the holder. But let's specifically talk about what happens, what you guys are saying, or what you want to do when you want it to become non-refundable. At that point, basically, the parties have to agree that it is no longer earnest money and it is now something else, a deposit or option money. So again, let me get into this a little more specifically. First of all, let me tell you also, the earnest money in our purchase and sale contracts, at least for the GAR, Georgia Association of Realtors contracts, and the RE forms contracts, it is not the consideration of the contract between the buyer and the seller. And you do need consideration for enforceability. But earnest money is not the consideration. So in the GAR contract, in the purchase and sale agreement, in the paragraph about due diligence, it does talk about due diligence period for the time frame. There is a second section under that paragraph, and that is paragraph A8B. It says option money for due diligence. In consideration of a seller granting a buyer the option to terminate this contract, the buyer, number one, has paid the seller $10 in non-refundable option money, the receipt and sufficiency of which is hereby acknowledged. Now, I get a lot of questions about this. Again, there must be consideration for enforceability of a contract. So, in essence, a due diligence period is a mini option contract within the broader context of the purchase and sale, so that $10 is the consideration for the seller granting the buyer the right to terminate for any or no reason, as long as they do so and send notice of that termination prior to the end of that due diligence period. When it says receipt and sufficiency of which is hereby acknowledged, that means it never actually changes hands. It's just to have consideration for that option. But then in the GAR contract, it goes on to say that in consideration for this option, the buyer shall pay the seller additional option money. Do you hear the difference? They're not calling it earnest money. It's option money of X amount of dollars, and then it gives the form by check, wire transfer, so forth and so on. And then either as of the offer date or within so many days from binding agreement date. Any additional option money paid by the buyer to the seller either shall or shall not be applied towards the purchase price at closing and shall be non-refundable to the buyer unless the closing fails to occur due to the default of the seller. So pre-printed in the GAR contract, number one, they talk about it as option money. Number two, it is paid, it is not held by the escrow agent, it is paid directly from the buyer to the seller. They negotiate if it goes towards the purchase price or not, and the option money is non-refundable. This is a separate set of funds, so to speak, from the earnest money. Now, the RE forms does not talk about, it does not have this separate pre-printed section about any option money regarding a due diligence period. Now, this money goes directly to the seller and potentially is non-refundable unless the seller defaults on the contract. And again, the special stipulation in the Georgia Association of Realtors, in the label they give it in and of itself, it does talk about the conversion, but in the verbiage itself, it does not. So in your special stipulations, whether you are including it as a special stipulation in the purchase and sale or as a stipulation on an amendment for the seller, like I said, generally we see it as granting an extension to a buyer's contingency. And again, either it is the pile of money that is already, the earnest money that is already on hold with the holder. And GAR has it as special stipulation 406, earnest money converted to a non-refundable deposit. That's what they have for their label. But the stipulation itself reads, in the event the buyer does not terminate the agreement under the due diligence period or under any other contingencies in favor of the buyer, the earnest money shall be paid to the seller, non-refundable, as consideration to the buyer exercising its right under due diligence provision. And again, that is very, it's a misuse of earnest money, because earnest money by nature, by definition, by its label, is refundable. They have it correct in the label. So you would have to say something to the effect of, for the seller granting, extending this contingency, so forth and so on. The earnest money on hold with the holder shall be converted to a non-refundable deposit to be dispersed to the seller should the contract not close or should the buyer terminate. And then you can negotiate whether that still gets applied to the sale price at closing or not. Get with Amy Davis, who authored the special stipulation coming at the end, or any of our affiliated closing attorneys to help you with the exact verbiage of that special stipulation. If before I release this video, if I get with them, I will link it below. But basically, the important part of this is if it is funds, if it is earnest money that is already on hold with the holder, in your stipulation, you must address the fact not that it's earnest money that's not refundable, but that it is being converted to a deposit or to option money. You must reference that conversion and no longer give it the label of earnest money in order to make it non-refundable to the seller. And if the seller is requiring additional funds to be deposited, either with an escrow agent or directly to the seller, again, you must label that money, those funds, as a deposit, option money, money for the right to extend the consideration for the right to extend the whatever contingency, so forth and so on. Bottom line, you cannot reference it as earnest money being non-refundable. Just because earnest money is refundable does not mean that it is always going to be refunded. If a buyer defaults on the contract, then the earnest money is the liquidated damages to the seller for the buyer's default. So the money that is on hold with the escrow agent called earnest money, again, doesn't necessarily in all circumstances go back to the buyer. The buyer can lose that earnest money depending upon the circumstances under which the contract fails to close, if that was a buyer default in the time frames and the agreements between the parties. Now, one of the issues our sellers face is, well, what happens if that is part of the purchase and sale agreement, but they never get the option money? Well, stay tuned, and I will share with you a special stipulation written by one of our fabulous affiliated closing attorneys, Amy Davis of Davis and Associates Law Firm. But first, let me go back to the contracts and let me mention to you a couple of special stipulations that GAR, Georgia Association of Realtors, and the RE forms have available for you, but I want you to take them with a grain of salt as special stipulations already pre-printed. So in the GAR contract package, if you look under the document that just has the whole library of special stipulations, there is a section under additional earnest money deposits and consideration. And for example, there is one section of additional earnest money, and if a buyer does put in additional earnest money, it is still treated as earnest money, number one. Number two, there is a section under earnest money converted to a non-refundable deposit. The issue is GAR, bless their hearts, they have that as the title of that special stipulation, but in the special stipulation itself, they don't actually use that verbiage, which they need to use, that it is converted to a non-refundable deposit, and they just talk about it as refundable earnest money, which again is incorrect. You have to talk about it being converted to a deposit or to option money. In the RE forms, same thing. It does talk about it being non-refundable, but you need to convert it from earnest money. Earnest money in and of itself, by its label, is protected and not necessarily non-refundable. It must be converted to another label, to a deposit, to option money, so forth and so on. And there is license law around this regarding how a holder who has a real estate license, i.e. a broker, must handle escrow funds. Once they have received escrow funds, not only is the holder directed by the contract regarding how those funds can come out of the escrow account, but the holder, the broker who is holding the funds, is also directed by license law. And under GREC Rule 520-1-.083b, it specifically says that in order to disperse the funds from a trust account, one of the ways is upon receiving a written agreement signed by all parties having an interest in the funds, separate from the contract that directed the holder to hold those funds. That directed the broker to hold those funds. So again, escrow money, earnest money, security deposits are there are very specific laws and rules and regulations regarding how those are handled, as opposed to how a holder can handle deposits, option money, so forth and so on. So now, again, we are so very fortunate. So now, again, the question is, what happens for a seller, especially in today's market, where this is February, it's March 2021, where a seller is expecting additional option money for due diligence period, and to take the house off the market for a specific buyer. And a lot of times, the majority of what we see in our contracts is that additional option money does go directly from the buyer to the seller. Well, what happens if the seller never gets it and the seller, a due diligence period is just a buyer right to terminate. It is not a seller right to terminate. What happens if the seller never gets those additional funds for the granting that buyer the right to take the property off the market, so that the buyer has the right to terminate? So we are very fortunate and very appreciative of attorney Amy Davis for having written a special stipulation for us regarding this additional option money during a due diligence period that protects sellers too. So let me read to you this special stipulation. And again, thank you so much to Amy Davis of Davis & Associates, and I will print her email contact below. She has written, all parties acknowledge and agree that upon receipt of the contract, buyer shall pay a non-refundable option payment for the seller to take the property off the market for a period equivalent to the due diligence period herein. The option fee shall be X amount of dollars payable to the seller. Said option money shall be separate and apart from the earnest money stated herein. Should the buyer fail to pay said money within 2 days of binding agreement date, seller shall have 5 days in which to terminate the contract, or the seller shall have waived that right to the option money. So thank you so much, Amy. We greatly appreciate it. In essence, what this does is, the way it's worded in the GAR contract for the additional option money, there's no right for the seller, there's no termination rights for the seller, and the seller is basically, if they were to default, if they don't get those funds, or during the buyer's due diligence period, they would be in default of the contract, and the remedies for default are spelled out in the contract, the purchase and sale agreements in and of themselves. So with this special stipulation, it does give a seller a termination right, so that they are not beholden to a buyer who is not sending this additional option money, so that the seller can terminate this contract under no penalty and not be in default of the contract and go on to another buyer. So I hope this contract tip helped you out, and thank you guys so much for watching. Dana Sparks, Broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.